Welcome to Washington Legal Foundation's web seminar program. My name is Glenn Lamey. I am Executive Director and Vice President of Legal Studies here at Washington Legal Foundation. We've been around for about 44 years now as an organization that started out as a litigating group that does original litigation, amicus briefs, regulatory comments, requests for regulation. We've sort of evolved from that beginning part to a group that still has litigation at its core, but also has a division that does publishing and programs, which is what I head up. This is one of our programs that we're doing this year on the antitrust issues. We'll be doing several more hopefully this year, and we'll make sure that you get invitations to that as well. So back in April of 2018, Competition Policy International published an intriguing paper by Elise Dorsey, Jan Rybnicek, and Professor Josh Wright that put the then sort of nascent effort to return U.S. antitrust law to the 1960s in the context of public choice economics and special interest rent seeking. As this Neo-Brandeisian movement took hold over the past few years, and its ideas were increasingly reflected in legislative proposals, and now from the leadership of the Federal Trade Commission, the views from that paper took on even more importance. We're holding this webinar today to help elevate these ideas for those who set, enforce, report on, and practice antitrust law and policy. Our speakers will discuss why a body of antitrust law that inspires more competition over how and when government will intervene than actual market competition is not only unlikely to achieve the Neo-Brandeisians' lofty goals, but could very well backfire. And you'll hear why the lessons of history and the basic fundamentals of economic theory support that conclusion. I want to let you know before we get started that this is being recorded. We also have available, if you click on the handouts tab, a copy of the slides that Corbin Barthold is going to use, and also a PDF of the CPI antitrust article that I had just mentioned. Also, if you have questions at any point in time, you can click on the Q&A tab and send that question. That will come to us, and we'll get to those questions eventually. So I'll introduce first, leading off, Josh Wright, who's University Professor of Law at George Mason University Scalia School of Law, and also is Executive Director of the school's Global Antitrust Institute. President Obama nominated Josh to serve as Commissioner on the Federal Trade Commission, and the U.S. Senate confirmed him on January 1st, 2013, a position he held until fall of 2015. He served at the Commission 3 times previously, including in the Bureau of Competition as its inaugural scholar in residence from 2007 to 2008. He's also, most proudly to us, a member of WLF's Volunteer Legal Policy Advisory Board. Following him will be Corbin Barthold, who is TechFreedom's Internet Policy Counsel and Director of Appellate Litigation. He clerked for U.S. District Court Judges Stephen Merriday and Robert Cleland. After his clerkships, he became an associate and later partner in the Los Angeles office of the law firm Brown, George, and Ross. And he also spent a few years as Washington Legal Foundation's Senior Litigation Counsel. Josh, if you could get us started.
Yeah, I'd be happy to. Thanks, Glenn. And it's a pleasure to be on with you and with Corbin to talk about these issues. And, you know, what academic doesn't love talking about their own paper a little bit. So I think it's a useful, I think what I will do with my time that can be the most useful to set the stage for the discussion is to kind of place where we are in antitrust history a little bit and why some of these public choice issues are probably more important than ever. The paper, Glenn, that you referred to, co-authored with Elise Dorsey and Jan Rybnicek, so I certainly don't get to take all or even most of the credit for the piece, laid out a bunch of predictions about what was going to happen at the agencies in response to sort of the Neo-Brandeisian challenge to the conventional wisdom of antitrust institutions and at that the legal framework and the consumer welfare standard. And I think you sort of fast forward a couple of years and don't get to be right in all the papers are right, but I think a couple of the predictions have become more important, and a couple of the issues that are more important to discuss. So I'm going to start kind of laying out some of the history, and especially for listeners who are not sort of deeply steeped in antitrust practice, or even those who aren't as deeply steeped in its history. The fight today, I think, is probably the most interesting moment in antitrust history that I've been able to be a part of, because in a sense everything is on the table. The consumer welfare standard writ large. So if you go back and you look at antitrust from, let's say, 1890 to, most people kind of start the modern era of antitrust in 1977. GTE Sylvania, the court sort of announces rule of reason for all of its cases, and an economic focus centered around interbrand competition. Sort of the economic era, I think, is, at least I really think of as being sort of born in 77 and continuing through a series of unanimous and supermajority decisions from the Supreme Court announcing that the consumer welfare standard is the law of the land. That is, antitrust institutions, substantive liability rules, procedural rules, remedies, and all of our antitrust institutions and rules would be sort of oriented around maximizing consumer welfare through protecting the competitive process. That was obviously not always the case, and I think Glenn's sort of pointed out in the intro. Some of the debate is about bringing antitrust back to the 1960s, and so I'll talk a little bit about what that means, what it was like in the pre-modern antitrust era. So if you go back in the cases from 1890 to 1977, courts really struggled with what the antitrust laws meant, right? You can look through the legislative history of the Sherman Act and the Clayton Act and find just about anything you'd like. Antitrust to protect consumer welfare, to protect small business, to protect particular industries, to intervene in particular contractual relationships, all of it, right? Agriculture, all of it. And the court really struggled, and the statutory mandate to condemn restraints of trade or monopolization or mergers that substantially lessen competition weren't very precise in the marching orders. And so courts, I think, sort of expectedly, were told by Congress, you guys go solve this. You figure it out which restraints are unlawful under Section 1, which business conduct monopolizes, which mergers substantially lessen competition, and which do not. Sort of predictably, courts, without a clear mandate about decision criteria, were all over the place. You can read those cases, and out of it, if I were to ask you the question, reading only cases from 1890 to sort of pre-1977, what are the goals of the antitrust laws? A little bit of a Rorschach test, right? You can find just about anything you'd like. Courts were confused. And so sort of and nobody was happy, I think, is a part of the history that is often skipped over. Ralph Nader and Judge Posner, and this is 1970s Judge Posner, or then Judge Posner, criticizing the FTC, the application of the antitrust laws. Bob Bork at the same time, obviously, famously doing the same in the antitrust paradox. Rules didn't make sense. Not just the criteria, but the rule just didn't make sense for achieving protection of small business, big business, consumer welfare, sort of just about anything. They were, antitrust really was, I think, an intellectual backwater and incoherent in terms of the analytical framework. If you look at body of decisions from the 60s, essentially, almost everything is unlawful. Nearly all horizontal mergers. There's cases like Vaughn's Grocery and Brown Shoe and Pabst Brewing, mergers to 4%, 5%, 6% unlawful. Almost anything contractually, maybe vertically now, not between rivals, but sort of vertically between, say, a manufacturer and distributor, whether it's resale price maintenance or tying or exclusive dealing or a vertical merger, almost all unlawful. And at that, much of it criminal, much of it facing the possibility of criminal sanctions. And it was in that backdrop, while economists were starting to study whether any of this made any sense, and starting to learn that some of the conduct we were condemning and sometimes criminalizing probably did enhance competition or was sometimes good for consumers. And we really needed a set of rules that didn't throw out the baby with the bathwater, right? Have everything unlawful and leave it to prosecutorial discretion, which conduct would be condemned and sort of which would not. And it was in that backdrop that the consumer welfare standard arose in the 70s, and a bunch of 9-0 decisions. This is, RBG and Scalia sort of together in opinions, and that created the modern era. And lots of fun disputes within the consumer welfare standard. You can, whether we're missing some cases, there are disputes now, and I think really worthy ones, of whether antitrust should focus more on labor markets or common ownership or sort of other areas. But one of the beautiful things about the consumer welfare standard has been its flexibility, right? It can adapt to new economic learning. It gives it an analytical framework to sort of cling to, and focuses our analytical effort on distinguishing conduct that harms competition from conduct that is either competitively neutral or harms it. That's sort of the framework now, kind of writ large, is we use the consumer welfare standard to help us create rules that identify and distinguish and deter anti-competitive conduct while allowing consumers to benefit from competitive conduct. Well, sort of fast forward 1977 to sort of current, I think you've got now what is the most interesting challenge to the consumer welfare standard that has, again, happened at least during my lifetime. And it's not happening in the courts. The consumer welfare standards are firmly established in the courts, but the rise of first Neo-Brandeisian sort of scholarship, we had Tim Wu, Lena Khan, et cetera, to advocate dumping the consumer welfare standard in favor of something that looks much closer to antitrust in the 60s. This was where originally, when I wrote about the topic, the label of hipster antitrust came from. It was sort of blast from the past kind of thing, and some tongue-in-cheek criticism about being too cool to face criticism over facts and evidence. They sort of relabeled themselves as Neo-Brandeisian, so I'm happy to use that label. But the critique really is the consumer welfare standard has failed in two ways. One, on its own terms, we're sort of missing a bunch of anti-competitive conduct that even under the consumer welfare standard should be unlawful, right? And then the second, I think more forceful critique, or more important critique anyway, is that antitrust focused only on consumer welfare is too narrow. We really ought readopt the goals of antitrust from the earlier era, and that the folks like me who criticized that earlier era for chasing a hodgepodge of socio-political goals, we've just got it wrong. That's what antitrust is for. We should be, so goes the Neo-Brandeisian critique, we should be revolutionizing antitrust, transforming antitrust to do more. We should have a more aggressive, ambitious vision for what antitrust can do, not just about protection competition, but reimagining the relationship between labor and capital, reimagining what market structure should look like, and using it sort of aggressively. That battle is taking place in a number of places. Professor Khan is now Chair Khan at the FTC. Professor Wu now sits on a competition council inside the White House. And so some of these views, I think, are now in places to do something about it, right? And the battle's taking place in advocating for congressional action that would undermine or eliminate the consumer welfare standard. I think a big agenda item on the FTC side of things is Chair Khan has announced some plans to do some competition rulemaking. We can sort of bracket for a side lots of fun legal issues. I know ones that both Corbin and I think about and care about deeply, so we can maybe talk about that a little bit later, about the legal authority to do so. But the desire to do so, I don't think there's any dispute over a desire to adopt some competition rules through as unfair methods of competition under the FTC Act that would sort of go beyond the scope of what would be allowed or permitted under the consumer welfare standard. So you've got the rubber hitting the road, both in Congress and within the halls of the FTC, with plans to do some rulemaking, and perhaps again in the courts. We'll see whether the FTC and DOJ, with its new leadership, I think John Cantor probably soon to be confirmed. Those agencies have amicus programs. They have tools available to them to try to advocate for changes in the law as well. So that's sort of the scope of the debate. Let me link it to what I think are the public choice concerns sort of laid out in the article, and then I'll pass things to Corbin. The key sort of core public choice insight is that regulators, like everyone else, respond to incentives. And what the paper tries to do is connect the Neo-Brandeisian program and agenda to what we can expect out of the agency in the future and what the implications are of those decisions for competition policy. And been interesting that the Neo-Brandeisian program for revolutionizing antitrust law has taken a couple of different turns. In its earliest iteration, both then Professor Khan and other Liz Warren, for example, Senator Warren, for example, advocated replacing the consumer welfare standard with something like a public interest standard, about as vague and sort of meaningless as you can get for a standard. And I don't want to paint sort of all of the Neo-Brandeisian school with sort of a single brush. There are some who argue for a public interest style standard. There are some who argue quite literally for the bright line rules from the 1960s, so the 1968 merger guidelines. The Open Markets Institute, for example, has a comment to the FTC saying those are the right merger rules, and sort of mergers to 10% are unlawful or something like that. So you've got some arguing for bright line rules that would make everything unlawful, essentially all mergers and conduct in the modern economy, sort of a broad swath of it, and leave to the agency the discretion of who to sue and when. The others advocate for a really broad standard that, again, leaves the agency all of the discretion to decide who to sue for what and when, in the ability to determine what conduct is illegal and sort of not. The key thread for those keeping score at home, obviously, is that in both cases, the agency gets all of the discretion, right? The agency has the discretion to determine what's unlawful or who to prosecute under a standard where everything is unlawful. And that, I think, is sort of the key connection to the rent-seeking sort of discussion to have. When an agency gets to pick winners and losers in contractual disputes between firms in a vertical chain, licensors and licensees, when an agency gets to decide, because the standard has no meaning, who wins and loses between two competitors, what we see in the world is those two competitors turn a lot of their competitive energy, resources, and attention to persuading the agency that they should win. Right? Competition moves from the marketplace to commissioners' offices or staff offices to try to persuade the agency that they are the good guy and you should sue the other guy, or intervene in a market that in a way that harms the other guy. I think the agency is inviting that. by advocating for these broader standards. And I think it is a bad thing for a couple of reasons. The one I've sort of already mentioned, we sort of shift competitive attention away from the marketplace and consumers as being the sort of ultimate adjudication of sort of who wins and loses in the marketplace to kind of a centrally controlled bureaucratic decision-making within an agency. I think that's antithetical to the goals of the antitrust laws, and I worry about it greatly. And I think the second great harm is a related one. Businesses sort of trying to organize their activities in a world where everything is unlawful, subject to agency discretion, is a problematic one that generates all sorts of costs that are also ultimately all sorts of costs to do with regulatory uncertainty and the lack of rule of law that are ultimately passed on to consumers in the form of higher prices, lower innovation, lower quality. That is exactly the critique, to sort of go full circle and bring things home. That is exactly the critique leveled at the feet of antitrust in the 1940s, 50s, and 60s so by all sides. And I very much think the centralization of decision-making and power in the FTC is an invitation to sort of circle antitrust back to that era. And we're already starting to see sort of first steps along those lines. The attack on the consumer welfare standard, sort of objective criteria that distinguishes anti-competitive from competitive conduct, sort of already underway. I believe within the first week of the new FTC taking over, they had thrown out the 2015 unfair methods of competition policy statement. Sort of FTC famously gave no meaning to its signature unfair methods of competition authority for 100 years. 2015 put out a policy statement that said, we'll follow the consumer welfare standard. I think it is no mistake, no accident that the very first thing that the Con Commission did was throw that thing out. Objective standards get in the way of a program under which sort of mushy, vague standards help empower the agency and help allow it to centralize control. There are other sort of signs of that, more inside baseball at the commission sort of things, but attempts to centralize power, take power away from minority commissioners, sort of do more through single commissioner control. But we can leave those for discussion. But I think that sets the table for you, Corbin. I'll stop talking, get out of the way, and hand it over to you.
Thank you, Josh. And thank you, Glenn. It's good to be here. Josh did some of the real hard spade work of setting our discussion in concrete terms, and now I get to do something fun and kind of go really big picture here. The somewhat provocative title of my talk, and I'll be happy to talk the concrete stuff after I'm done in the discussion as well, definitely. The somewhat provocative title of my talk is Antitrust and the End of the World. My themes are going to be complexity, the difficulty of predicting the future, and what they mean for what Josh referred to as a socio-political antitrust policy. And I'm going to filter those topics through the lens of whether society is heading toward collapse, because I thought that'd just be fun and different. So time is short. I'm going to paraphrase a lot of the content in these slides. I apologize in advance for that. I know that's a little annoying. If the talk interests you, I invite you to go back and read the slides in the printout or in the video. Here is a quote from an Oxford philosophy professor about the likelihood of societal collapse. Given everything I know, he says, I love that part, the odds of such an event this century are around 1 in 6. A lot of us probably say things like this when we're sitting on a bar stool, but it takes an Oxford philosophy professor to write down such a statement and put it in a book. This statement, I put it to you, is what scientists call not even wrong. It is untestable. It is unfalsifiable. It sounds kind of precise, but it's actually gibberish. So what leads a professor to say such a thing? And I suspect one factor is a failure to distinguish two very different kinds of phenomena. On the one hand, there are aspects of our world that display pretty regular behavior across time. Newton's laws come to mind. They allow SpaceX to do really amazing stuff with rockets. And it's not just pure physics. There are, for instance, a lot of really interesting power laws. On the left, we have Zipf's law, which accurately describes the rank frequency distribution of words in almost any large body of text across languages. On the right is a chart showing Kleiber's law, which says that metabolic rate scales with body mass to the power of 3/4. But the list of stuff in the world that acts in a regular and predictable fashion gives out surprisingly quickly. The world is very chaotic. And it's chaotic at pretty much all scales. So here we have a small scale example. This picture shows the course of a double rod pendulum. Its behavior is so highly sensitive to initial conditions that for human purposes, its paths are just sheer disorder and unpredictability. I invite you to go online and see a video of one of these things in action. It's fun. Human affairs writ large are permeated with a similar sort of chaos and complexity. And as a result, a lot of human endeavors just aren't really amenable to neat cost-benefit analysis. In a great book on uncertainty, Mervyn King and John Kay give a lot of examples, and one really arresting one, just vivid, is Columbus. He, of course, was seeking a trade route with the East Indies. Even with all available information, that was an iffy proposition. And needless to say, the pertinent actors were proceeding with grossly incomplete information. And the world is full of those kinds of unknown unknowns. In consequence, as King and Kay explain, the proper answer to most questions, who will win the Kentucky Derby, is I do not know. And really, it's hubris to talk in probabilities about irreducibly complex phenomena that we can really only understand at best in terms of stories. So when discussing the end of civilization, I cannot give you probabilities, but let me tell you a little story. It starts with one of my favorite books, The Collapse of Complex Societies by an anthropologist named Joseph Tainter. And Tainter investigates societal collapses across history, like the Olmecs, the Old Kingdom in Egypt, and so on. And what he finds is that there are diminishing marginal returns on complexity as a tool for problem solving. And I'm sorry to skip along here, but I have to pass that one by. The core idea is that in a large society, administrative bodies tend to proliferate to the point where they stop adding value and start being a drag. And then meanwhile, expenses have a natural tendency to pile up, but are rarely scaled back. And this is true of welfare programs, of legitimizing costs for the state, of compensation for elites, and really much more. You start to see it everywhere once you think about it. And eventually, in attempting to deal with the complex problems that are presented by a complex world, the society itself becomes so complex and sclerotic that its capacity to keep problem solving grinds to a halt. And public choice theory plays a big role in this analysis. So both Josh's paper and Tainter's book discuss the work of the economist Mancur Olson. And Olson sees this negative feedback loop whereby regulators pump out rules, specialists find holes, so the regulators make more rules, so the specialists are needed to even navigate the system, and so on, in this explosion of work that doesn't involve actually building or doing or solving anything real. I think the most vivid of Tainter's case studies for our purposes, is the collapse of the Roman Empire. So Rome expanded for all kinds of interesting reasons that we can't get into here, but its expenses increased disproportionately in the fashion I've just discussed. And when the empire stopped expanding, it stopped gaining new revenue from conquest, yet it kept spending. And the result over the course of about 100 years was debasement of the currency, spiraling taxes, crumbling services, and ultimately insolvency in what's known as the crisis of the 3rd century. That chart on the right shows the amount of silver that archaeologists find in Roman denarii over time. That picture really tells the tale. So the Western Empire survived the crisis, but it was never the same. It limped along as a massive, bloated, authoritarian bureaucracy, basically reliant on a bunch of really futile central planning. So if you were a farmer, the state decreed that your son had to be a farmer too, and that you had to pay taxes on the land adjacent to your land if your neighbor farmer vacated it. And you can guess how effective such central planning was over time. So by now you might see some parallels to our current situation. I'll leave those to the viewer, but I'll touch very briefly on some other little stories that are also worth considering for our present purposes. One comes by way of the anthropologist and complexity scientist Peter Turchin, who believes that successful societies have a tendency to overproduce elites. And the shorthand for this, I suppose, is a bit glib, but are all the jokes that get made about people with gender studies degrees, working at Starbucks. But another great example is the proliferation of lawyers, and lawyers working up, paper and fighting in court and finding new ways to fight. But the upshot is a proliferation of disgruntled people whose lives don't meet up to their aspirations, and a lot of acrimony and shouting, and an uptick, especially in the costs of legitimizing activities by the state. And then another person worth taking a quick look at is the political scientist Stephen Tellis. And he talks about how our society is becoming a kludge or kludgeocracy. A kludge is a computer science term for a MacGyver-style patch of a glitch in a program. And as such duct tape fixes proliferate, the overall system becomes more complex and ultimately incoherent. And the picture on the right is about the Affordable Care Act. But just generally, anyone who follows administrative law closely will sort of intuit what this slide is getting at. Think of DACA, think of agency guidance letters and the fights that occur over them, or the litigation over what qualifies as final agency action. Examples abound. I mean, this slide is sort of worth a lecture unto itself. And finally, I'll quickly point out, we're never going to be rid of people that think that just a little more central planning, just a little more top-down control, and we will reach utopia. Humans have a strong desire to believe that things are not chaotic, that they can be ordered. And just a fun little example is these squares. People often miss that the top right set of squares with its nice, neat, no colors touching arrangement is not random. The boxes with colors touching are random, just like how random coin flips will occasionally lead to like 6 heads in a row. There's this natural tendency to sort of paste order and coherence and meaning onto events. And the next thing you know, you're saying that either the Rothschilds control the weather, or that it makes sense to have a national industrial policy, or that the odds of societal collapse are 1 in 6. So before we all just sort of go home and cry, one big thing we have that the Romans did not is a large amount of innovation. So Norman Borlaug, who developed high-yield wheats and helped drive the Green Revolution, he can serve as our sort of poster child here. And the accumulation of innovation has done wonders over the last few hundred years. As I hope most of you know, life expectancy has risen dramatically. So innovation can not only push off societal collapse, it can dramatically improve lives and living standards. And so that brings me to finally, antitrust. Not surprisingly, given what I've said above, some people think antitrust can basically be used to create what you might call planned innovation. And not surprisingly, given what I've said above, I think the notion that those people can predict and guide the direction of markets and innovation is dubious at best. And for purposes of discussing both public choice theory and the end of the world, it's good to focus, especially when we talk about antitrust, on how when it malfunctions, when it becomes this open-ended socio-political project, it can wind up being one of the biggest, best possible examples you will ever see of the sort of accumulated organizational expense and deadweight loss that Tainter focuses on. So if antitrust is not pegged to clear rules, it becomes a tool for basically political and intercorporate warfare, as Josh was kind of getting at. Is an innovative rival disrupting the market? Like, go ahead and just file a lawsuit against it and see what happens. Just duke it out in court. Like, when the standards are open-ended, you might pull it off. Especially, you find some hot docs. You find the company, like all company executives, they want to compete really hard, and you throw those emails in front of a jury and it looks really good. Is a company getting too big in your view as a government regulator? Well, go ahead and just start an investigation. It becomes rational to pay for armies of lawyers to rent, seek, and lobby in search of advantage. So the ultimate example of antitrust gone wrong in these ways, perhaps, is the IBM antitrust litigation. The government decided that IBM's success in the market for mainframe computers was a problem, and the lawsuit spun completely out of control. It spanned for more than a decade, and it involved hundreds of lawyers. And meanwhile, the world just moved on to personal computing, rendering the whole affair just pointless and destructive. And to top it all off, the lawsuit probably actually led IBM to raise prices on some of its products out of fear that lower prices would lead to further government retaliation. And Josh talked about the whole body of law in the 60s and 70s, which is of a similar flavor. One case I'd add to his list is the Utah Pie case, which maybe we can get into. But as Josh pointed out, examples abound. I think the IBM one is just particularly egregious. So you might hope that this kind of deadweight loss would be sobering and sort of a lesson for modern times. Not so. And I'm going to skip through this one pretty quickly, but Tainter, for what it's worth, isn't optimistic about how long innovation can help us stave off collapse. Technological innovation and increasing productivity, he writes, can forestall declining marginal returns for only so long. I do want to note, that view should be taken seriously. The evidence does suggest that innovation is becoming more expensive, and the amount of productivity growth created per researcher is dropping. I see this as evidence for making sure antitrust doesn't get in the way of innovation, because it's a precious thing and it doesn't just fall like manna from heaven. It's not automatic. I don't know, maybe it is, but that's a big assumption. And you have to bear in mind also that a constant rate of growth, which we've become accustomed to, actually requires an exponential amount of growth. So we are running, in effect, on an accelerating treadmill when it comes to needing innovation and technological advance to stave off collapse. So we have to constantly do more and more with less and less. Now, people like Ray Kurzweil say, like, no worries, we're just going to fly into the singularity. And that view seems pretty out there to me. But that chart of his on the right does give a good feel of this treadmill effect. It charts information processing on a logarithmic scale, basically saying that Moore's law has been going on for longer than just the period that Moore charted it. And you can imagine the rate of constant innovative breakthrough that is needed to keep such a growth trajectory going. So to return to, the end of the world, where are we headed? You will not be at all surprised at this point to hear me say, I don't know. I think the theoretical physicist Geoffrey West has it right when he observes simply that the cycle of innovation will be continually repeated, thereby pushing potential collapse as far into the future as the creativity, inventiveness, and resourcefulness of human beings allow. And frankly, it should be pretty intuitive that you have to be wary about the people who speak with any more certainty than that. If you look at things on the scale of your own life and just extrapolate from that, it should be pretty clear that people who claim they can guide markets or that we have to have degrowth or whatever, that there's this certain centrally planned course we need. Those people are basically just making proclamations of faith. I love this quote from Isaiah Berlin describing the outlooks of Tolstoy and Joseph de Maistre. He said, "Battles are won by acts of faith, and life itself is a battle of this sort, and any attempt to describe it in rational terms is really a kind of dreadful distortion." And, Napoleon didn't really know what was going on at Borodino. Mark Zuckerberg doesn't really know where Facebook is headed or where the social media market is headed, never mind government officials. And no one really knows the ultimate fate of society. So all I can tell you is that our track record so far has been pretty good, that sort of radical degrowth movements or radical centralized industrial policies are themselves risky and uncertain and likely to cause widespread misery. And then frankly, optimism seems like a pretty useful adaptive trait. I'm really not sure how you can have civilization without it. So with that journey up to the 10,000 foot view, I'm happy to come back down and we can talk about the FTC and all that fun stuff.
Josh, any high-level thoughts on Corbin's high-level presentation that maybe have REM's "it's the end of the world as you know it" in the back of my head the whole time?
That was fun, and it makes me feel like Corbin's got a natural tenured professor sort of living inside him that needs to be let out. And I learned a lot, and I appreciate it. I do think the sort of this core insight at the end really is at the heart, whether sort of my inside the weeds FTC stuff or from a higher level, this sort of optimism and belief about the ability to structure markets by counting the number of firms on our fingers and deciding which is the right one. I think it does, that sort of belief does lie at the core of a lot of the regulatory agenda currently sort of at the FTC and motivating some of the Neo-Brandeisian attack on modern antitrust. I think it is no surprise with that as the premise that there's a natural hostility towards economics within that movement, some calling for sort of purging economists out of the FTC altogether. Sort of some hostility that is more tame than that. But I think those two sort of go hand in hand, because the former set of beliefs requires a rejection of looking at the results of what happens when you go and test those beliefs against data.
Well, Josh, as someone who really follows this stuff at the most thorough possible level, one question I have for you about I'll just call it the socio-political antitrust movement, but to what degree is the case you've got it wrong if we atomize business that will make space for innovation, and actually we're right on what is needed for growth? And to what degree is the case really, okay, we admit that that's a ruse, we actually just don't like growth, we don't like innovation, and what we'd rather have is something closer to the status quo, something that's a little more comfortable, we don't want the world to move so fast attitude?
I'm going to take door number 3, and in the following ways. So I think there's some elements of both and some elements of neither, to be sort of a little bit more precise. So a few things. First, I think there is very much the belief that you can tinker with markets, redistribute at will, play with the design of property rights, or eliminate them with all good effects, no bad effects. I think there's just sort of an operating premise that you can do that at no cost, and that's obviously wrong. But I think that is an operating premise, at least in some corners of that movement. The second is one difference between the 1940s to 60s style antitrust structuralists and the Neo-Brandeisians is the structuralists were at least consistent. The 1940s to 1960s structuralist, it was big is bad, small is always better. And it turned out, I mean, that stuff, at least you go read Joe Bain from Harvard in the 1940s, that was the paradigmatic view in IO economics in the 30s and 40s. And it ended up being wrong. But at least, there was an analytical framework that rationalized it. Okay. The Neo-Brandeisians, it is structure is big is bad unless I say it's good. Because there's all sorts of behavior that would also be condemned under the existing antitrust laws that they would say is okay if it's the right person. I'll give you sort of right person doing it. I'll give you two examples. One is activities by state or local governments, right? State or local government grants of monopoly power to private actors, completely off the table, right? Absolutely, that form of monopoly power is okay. It's part of the democratic process, and whatever the socio-political hodgepodge of goals is, for reasons that I do not understand, they are largely okay with. I have a conversation somewhere that I did as part of GAI with Matt Stoller, where we talk about this a little bit. Occupational licensing, just fine. Outright grants by state and local governments to pick winners and losers that generate monopoly power, no doubt about it. Perfectly fine, right? They've got nothing to say about state and local granted monopoly power at all. And in fact, openly criticized the Biden administration for including elements of that in the big expansive competition executive order they did. That's one example. The other is sort of expressly embracing the idea of collusive behavior between on the labor side of the market, or between sort of particular actors that are more favored. So big criticism for the FTC for it had cases, some of these were when I was there, we entered into some consents with it was piano teachers and ice skating teachers, and who had an agreement in their trade association that you fix prices. And so, we sent a lawyer out to say, please stop it. Don't fix prices for people taking piano lessons. And, no fines, no nothing, but they get under order and they sort of go on their way. Big criticism, not that that's a waste of FTC resources, which might be a legitimate criticism. It ended up, one lawyer spent 10 hours on 3 cases, right? Their criticism was that collusion's okay. Plain vanilla violation of Section 1 of the Sherman Act, but that's okay because we like those guys. And that to me is the more, maybe in terms of economic impact, the first inconsistency is the bigger deal. The second one, if sort of magnified, is the bigger problem. Because I think what it means is it sort of it is a predecessor to the exact form of hubris that you talk about. It is putting themselves in the shoes of picking winners and losers in the race for innovation. And I think that that's a dangerous formula. And I think one that gives me great concern. But that inconsistency is, I think, a key feature of the Neo-Brandeisian program. It ultimately is never going to be a set of bright lines. I can imagine a really strict antitrust regime that's a set of bright lines that I think are intellectually bankrupt, not supported by the economic evidence, for example, that are bad for the world. but are consistent with rule of law and, consistently applied. I don't think that's what we are getting and are going to get. I think very much what we are going to get, to the extent there are bright line rules that operate in the same way as the amorphous public interest standard style. Everything's illegal, and it is up to your benevolent bureaucrat to determine who is prosecuted and who is not, and what those consents look like, right? So in both cases, I think the sort of picking winners and losers, the sort of Hayek's fatal conceit point looms large.
So is it fair to say that there's kind of a direct correlation between expanding the discretion of the regulators at FTC or at DOJ and the chilling effect that results? It almost seems like the leaders of the FTC know that it's going to be a long slog to actually go out and enforce the law or bring cases. So they're trying to do this shock and awe of putting out all these new standards or getting rid of the old standards and hope that it deters market activity, which could be good or it could be bad market activity.
I think that's right. And I think what you're seeing now is an invitation from the agencies. If you look at what the sort of rent-seeking competition that is invited, the sort of contours of that competition, in the tech markets that are getting all of the attention now in particular, but the lesson really is across the economy. There's money on the aggravating side of these cases, right? It was famously sort of Microsoft and Yelp in the Google case, and Apple in the Qualcomm case, and News Corp with all of them, and right there's there's a lot of money on all sides, because the antitrust disputes are high stakes. It's high stakes games when you pick winners and losers in sort of big important markets, to be sure. But what is invited, and I think it's sort of proved to be a successful model, at least with this commission, rent seeking in those markets gets you something. And whether it gets you legislation, whether it gets you a favorable rule, whether it gets you a case being brought, I think the model is that is an avenue with a high rate of return. And
well, yeah. One thing that's worth mentioning is, even if and this is true in lots of litigation rules, a very small chance of success, if enough money is at stake, creates a positive value probability. If you only have a very small chance of succeeding in kneecapping a competitor. But like, you look at, just one example that pops into mind is the Apple Samsung legal trench warfare that they had for a while. When there's billions and billions of dollars at stake, suddenly the $20 million that your white shoe law firm gins up is just a rounding error and absolutely worth paying.
So you mentioned the private litigation there, Corbin. How do you think what's happening in the government sphere is going to influence private litigation? Are we going to see more rent-seeking oriented private litigation? And will the courts still follow the consumer welfare standard and the antitrust laws that as they've been interpreted over the last 30 years in those kinds of private legal disputes?
Well, that was sort of one sort of tractable question with one crystal ball question, I think, because I try not to be too mean when I kick shins of plaintiffs' lawyers, but they always are watching what the government is doing and giving follow-on lawsuits to test. It's a game of whack-a-mole. You test for leaks. So whatever the government does, you're bound to have follow-on copycat litigation from plaintiffs' lawyers. And sometimes that's kind of ham-fisted, and sometimes it's very competent and goes a long way. The key example we see right now, although I will be honest, it actually was the plaintiffs' lawyers doing the innovating on this one, is Apple versus Pepper, and the Apple Epic case, and then the government's activity about app stores. It's this symbiotic relationship where they're all learning from each other. They're all, seeing what discoveries in their given cases. So I think there's a natural tendency that where the government goes, plaintiffs' lawyers will follow, and sometimes vice versa. But as to whether the courts will follow the consumer welfare standard or continue to or shift, I mean, that's first of all, it's the $1 million question, and second of all, that is looking for a high element of prophecy. I mean, I believe that one of the reasons you're seeing so much effort and so much attention put into the FTC is, you go where you think you can make stuff happen. I think Congress moves slowly for reasons both by design and both our current situation. So that's been kind of a dead end. Maybe that'll change. And the courts have a system whereby people tend to operate on precedent and they follow the rules that have been set by the Supreme Court. So to change the rules there would be a long, drawn out, perhaps decades long process of reversing the consumer welfare standard. So you go to agencies and you just try and see if you can make quick action occur there, where there's very little democratic accountability. And it is an interesting question going to the 6G stuff and rulemaking about whether the courts are going to smack down the FTC and it's going to end up with less power than it started with. But that's just a long-winded way of saying, I think it would take time. It would have to be slow. It would be sort of a crack here and a little opinion there. And a movement would have to grow from the ground up in the courts. Whether or not that will happen, I mean, I have no idea.
I'm happy to place $1 million bet on the $1 million question. The courts aren't going anywhere. And I think it's for a couple of reasons. I mean, without legislative intervention, I think it's for a couple of reasons that all the reasons that Corbin said are sort of well established. These are 9-0 cases. These aren't particularly controversial cases. I don't think that there's judicial demand to make antitrust standards and already complex cases mushier. I don't think that I spend a lot of time teaching and talking antitrust to judges. I think the demand for that is zero from judges. And you can do anything you want to do under the consumer welfare standard. People come in and there's the adversarial process on both sides. Plaintiffs win cases under the consumer welfare standard. The FTC's rate in merger litigation is something like 85% win rate. That's really high. I think it's too high. That puts me sort of, out of the modern discussion where I guess it's supposed to be bigger than 100% or whatever. But I think it's not going to happen in the courts. And I think the FTC chair and before that Rohit Chopra knew this. I mean, to their credit, their plan has been, I can't get what I want out of the courts. Let me lobby Congress, and in Lena's case, sort of work in Congress with Cicilline, or do rulemaking, because we can't win in the court. So fine, off we go and we run on those battles. I do think one interesting wrinkle that is happening right now in antitrust and in mergers in particular is the FTC has just about abandoned the Hart-Scott-Rodino merger review process, sort of de facto abandoned the HSR process. And so there's a lot of antitrust practitioners and FTC staff who have grown up around that process. I come in as a representing parties in a merger, and FTC staff wants to negotiate a timing agreement with me to give them more time. We're negotiating a divestiture or a settlement. There's a process that has grown up in the shadow of an FTC that makes credible litigation threats. And that brings the type of cases that generate an 85% win rate. Practitioners have learned how to live and play in that environment, and so have FTC staff lawyers. In a number of occasions already, what has happened is FTC staff have reached a settlement with parties to challenge a merger, have a divestiture, and then sort of move on. And this FTC has said, no, we don't agree with your view of staff, your view of the law, and we're going to throw out the settlement and go sue. It's not a surprise you're seeing FTC staff leave in that environment, right? Their input's not as valued as it was before. And not to mention can't speak in public places or whatever the gag order that was imposed on staff is, right? So it's no surprise that you're seeing an exodus of both lawyers and economists for that reason. But that's not, where the real rubber hits the road on that stuff is the antitrust practitioners that grew up around that practice learn to respect the FTC for making credible threats in that context. When the threats are no longer credible, a bunch of smart antitrust lawyers in the bar, I think it took them until a week ago, 2 weeks ago, to figure out that the threats aren't credible anymore. And an FTC that tries to live on their reputation of credibility to make threats, to get parties to back down from mergers or enter into settlements, but brings bad cases, that's not an equilibrium. I think there are a lot of antitrust practitioners who are right now advising clients when they've got proposed mergers to go to staff and say, remember how we used to cooperate and give you extra time? No. Hart-Scott-Rodino, you got 30 days, you do a second request, you got 30 more, see you in court. We love you, we brought you coffee and donuts, we still like you, staff. You recommend whatever you want to recommend, but we'll see you in court in 60 days. Because if you're going to bring a bad suit, we're just going to close and you come chase us. And that is a world in which I don't think the current FTC has thought all the way through, because you're going to have a lot of parties, and I don't just mean tech mergers. You have a lot of parties doing that. You can't sue them all. And even if they get this ridiculous budget increase, you can't sue them all. And I'm not sure who's left over to write all your rules and implement the rest of your agenda. I'm not sure sort of they've got a coherent strategy across those pieces. I think that there's a sort of short-term view that the world will treat threats as credible, but I think that's not what we're going to see. And you're going to see a bunch of litigation with a bunch of bad cases.
Can I just jump in on the litigation point, because I think there's sort of two things going on, and to be mischievous and push back a little bit on the what the courts will do. I agree with you. There's not going to be some chucking of the consumer welfare standard overboard, but there's all kinds of ways judges can create little mischief. And the main case I'd point to is Via Media versus Comcast in the Seventh Circuit, which basically potentially makes it so that you can no longer dismiss a refusal to deal lawsuit on the pleadings. You always have to go through and do discovery and go to summary judgment. And judges that have decided that they want to have rollbacks, there's all kinds of little ways they can do it like that. But then the interesting question is, given the Supreme Court and where it's at, as these things get challenged, and this is something we brought up a couple times, so the FTC, maybe they see decisions like that and they go, there's blood in the water. They do things like say, we can make rules, unfair competition rules under 6G of the FTC Act. And the next thing that happens, they run into this buzzsaw up at the Supreme Court where they say, what a great opportunity to sort of revive the non-delegation doctrine and say that that's legislative power, So I think it's the dynamics. There's almost these eddies that are shifting and flowing where you might get these little victories, and then boom, have some giant, Supreme Court ruling that sets this whole movement back, or it all ends in tears. I mean, again, I don't know how it'll play out, but there's some interesting moving pieces.
Absolutely.
So if the Justice Department's antitrust division under Jonathan Kanter sticks to their guns and says, we're not getting rid of the vertical merger guidelines, we're going to be incremental in our approach, does that just create more opportunities for rent seeking? Obviously, DOJ and FTC have their agreements as to who reviews which mergers and which cases they bring, but I could still see companies going to sort of shopping agencies.
I think you'll see a little bit of that. I think you'll see attempts also to rent seek with Congress to affect that divide. I think you'll see some of that. The clearance agreement's pretty well set. And I suspect that the Kanter DOJ will drop the vertical merger guidelines too. I don't expect much distance, but that's another thing where, what the law of the land is on vertical mergers without the guidelines is AT&T Time Warner. I mean, throw merging parties into that briar patch is just fine compared to the vertical merger guidelines. Is another thing I think without maybe a symbolic sort of, high-fiving within the agency, but in terms of actual impact, the case that Article 3 judges will read is AT&T Time Warner. It's the Court of Appeals decision on vertical mergers. It is the law of the land. Now the agencies will take 6 months or a year and they'll try to replace those guidelines. But a fun thing to watch, I think, will be, one of the reasons those guidelines have meaning is because they were written in a serious way. They are persuasive to Article 3 judges because they are helpful. They are connected to the economics literature. They are empirically grounded, and they have been persuasive with Article 3 judges who want some help in antitrust cases. You don't just get to write guidelines at the agency and have Article 3 judges say, yes, I'm going to follow this. You're going to have merging parties say, these are bad documents and you don't need to follow them. And we'll see what happens. Early on in the removal of those guidelines, the FTC majority, the 3 Democratic commissioners said, you know what, one of the reasons we don't like those merger guidelines is because they allow for any efficiencies defense. Our guidelines mention efficiencies and that word's not in the statute. That's a silly argument. And it's one that I can't imagine any Article 3 judge that took law school seriously being persuaded by. The statute says mergers that substantially lessen competition are unlawful. Mergers with efficiencies that help you enhance competition don't substantially lessen. There's a statutory argument to be made. The idea that they were going to throw out the guidelines because they choose not to believe in merger efficiencies is wishful thinking in terms of its persuasive authority with courts.
Josh, can I ask you, now that the UMC policy statement has been kiboshed, if the FTC is going into court trying to apply the FTC Act in a way that goes far outside the jurisprudence of the Sherman Act, do you see the courts coming up with some theory that says, well, no, they have to be connected, or
yes,
some kind of, yeah? Could you elaborate on that?
Yeah, and this was absolutely a key part of the discussion for the guidelines. I mean, one of the reasons why those guidelines got 3 Democratic commissioners to vote for them, despite when I came in and said, let's do this, all I was told was no by everybody, every day. One of the selling points for the 3 Democratic commissioners was when we discussed bringing UMC cases, we were scared to death to go to court. We were scared to go to death to court without guidelines because the idea was, other than maybe invitation to collude cases, the court would define the authority for us in a way that the Democratic majority didn't appreciate. It would sort of put on too much of a binding constraint on application of the UMC. I said, well, then let's write something down. And you tether it to the consumer welfare standard. And it's got some play in the joints, but it is tethered to the consumer welfare standard. And you take that option off the table. And now that lets you, when parties sort of push back and want to litigate, it lets you say, okay, well, let's go litigate a UMC case. That's an option that I think the FTC wanted to have, but could not ever threaten credibly. And I think that problem generated the rest of the nonsense around administrative adjudication at the FTC, that, the 100% win rate in terms of ruling for itself on claims, not on cases, not claims. It always ruled for itself. It extended out the process a long time to generate settlement pressure on defendants because they were afraid to go to federal court. And so they didn't. They avoided it like the plague. And I think they avoided it like the plague because, we've got other guidelines, UDAP guidelines, for example. We've got other guidelines that take cracks at what unfairness means. Judges have a good sense of what competition means. I think that there was legitimate concern that a court, probably the DC Circuit, would say something like, something more constraining than the UMC policy statement was. And I think that concern lives on. I think it is exacerbated by the removal of the guidelines. And I do think, and I've written this I think I wrote this in the Wall Street Journal, if not bunch of places. I think the removal of the UMC policy statement, even understanding the goals of the FTC, which I disagree with, I think will end up proving to be short-sighted and backfire. They're going to have to win in an Article 3 court, and doing that doesn't help.
Corbin, any final thoughts?
Oh, this has been great fun. No, thank you, Josh, for letting me have this talk with you. And it's a great paper, Josh's paper. I recommend it to everyone. And also, he has a recent op-ed in the Wall Street Journal about why not to let Brussels set our antitrust policy that I would direct everyone to.
I'd also recommend a piece that Carl Shapiro and Herbert Hovenkamp wrote recently about the vertical mortgage guidelines that makes somewhat the same point that Josh made, which is that it's a preposterous argument to say that we need to get rid of it because the word efficiency is not in the statute.
But yeah, I guess one actually real final thought is Josh. He's absolutely right. A lot of these questions are ultimately going to be decided by courts, and there may be a very interesting appeal on this 6G rulemaking authority and on other issues. So the FTC is not going to be the final decider on a lot of this.
I agree, and I think that's right. I think a lot of the rulemaking agenda, it's going to be a while till we get there. I think we're going to enter a 2-2 period, and then we'll get some rules after. But I think there's either the FTC is going to have to lay down on a bunch of mergers because they're going to have their bluff called, or they're going to have to run into court for a bunch of PIs on bad cases because they don't like where the law is. But they're going to be going to court a lot, I think, if they want their threats to be taken seriously. They're going to end up going to court quite a bit on mergers. And I think they're going to be ending up going to court on the rulemaking agenda. I will end on the thought that it sure does seem like a bad time to be pushing all of your experienced antitrust lawyers out of the building.
Josh, Corbin, thank you so much for taking the time to do this today, and thank you everyone in the audience for tuning in. The recording of this is going to be available a little bit later today, and I will send it around to all the attendees and registrants. But if there's anybody who wants to send it out to others, the more that we spread this word, I think the more thinking and pondering that needs to be done will be done. Thanks again.
Thank you.